Welcome. You're listening to Realty Resource Radio with Greg Swearingen and Lori Swearingen. We've been realtors in the Columbus market for over 20 years. We have a team of 5 agents ready to serve you. And we are here today with a special guest, Richard Meyer.
Yep. And before we get going with Richard, I wanted to just mention that we are looking for a country music band who would like to get some of their music on our radio show.
Yes, so McGuffey Lane, if you're listening.
I know you want to talk to them.
I do.
But anybody, really, that is a musical band would like to get some of their music on the radio, we'd like to talk to you about doing our intro into our show and then playing some of your music as well.
So go to our radio or our website.
Yeah, realtyresourceradio.com.
And you can contact us.
Yeah, there's a music link there. Mm-hmm. It talks all about it. You know, in our next segment, we're going to be talking about sub-metering because there's companies that are passing bills on to you through the utility company. So if you're a renter and you're someone who's renting from someone who does sub-metering, your utility bills are much higher because in a lot of cases because they're trying to pass costs on to you through your utility bill, and we're concerned about that. We're going to be talking about that in the second part.
And you can go to our website or to YouTube and download last week's segment, right?
Yeah, it's going to be out there.
And watch it because it was all about this subject as well.
Yeah, and we're going to talk some more with someone who knows a lot about it.
Okay.
You know, we've got someone with us here, Richard Meyer. He's been a licensed attorney for 35 years and practiced in Ohio. He's a member of the National Academy of Elder Law Attorneys, the Ohio State Bar Association Trust and Estate Section and Elder Law Committee, and the Columbus Bar Association Probate Committee. He's an OSBA certified specialist in estate planning, trust, and probate law, one of the reasons we have him here today. He's a past chair of the Ohio State Bar Association Elder Law Committee. He is president of Ohio chapter of the National Academy of Elder Law Attorneys. His law firm, Browning Meyer, is leading the way across the United States for elder law issues. Browning Meyer has a focus on elder law, probate, customized estate planning, including special needs trusts and asset protection planning. I could go on and on and on. This resume is huge. We're lucky to have him here with us so we can talk to you, talk to us about probate, about estate planning, why we need it so that we can minimize the taxes we pay to the government, really. Welcome, Richard Meyer.
Well, thank you.
Yes, and I want to personally thank Richard as well because Greg told me who was coming on, and it just so happens that he actually has my parents' house in a trust account. And so this means it's extra special to me to have him on today.
Thank you.
Yeah. You know, my big concern, Richard, and I think a lot of people have it, is, I mean, we don't like to talk about death. We try to put it off, not think about it.
Right.
But in reality, it could happen at any time. And I was thinking, you know, just on the news the other day, it's crazy because I would joke with my wife. I'd say, you know, well, the only thing we really have to worry about is if we get hit by a plane. And one actually crashed into a house and killed some folks. Yes. You just don't know. You could get in a car wreck tomorrow, today even.
Correct.
Listening to this radio show on your way to church or something. So you don't know, you know, when you're going to die, but you want to be prepared. Mm-hmm. And you want to be prepared, and you know, the focus on this show is helping people out, and we want to help people out so they pay like the least amount of taxes. Right. So that when we do pass away, the stuff that we have, we give it to our kids and the charities we care about or the people we care about, and it doesn't get all tied up in court.
Sure.
What can we do? Do you have some general ideas?
Is this where the question I know we had our family is Richard has my parents' house in an irrevocable trust. Mm-hmm. And you know, we were I really don't know exactly what that is. And would like Richard to explain that. Actually, I know that we've had questions about that, like why now? We can understand when we were little, you know, under the age of 18, but we are all well above the age of 18 now, and just wondering why, you know, why would it be beneficial to have it in an irrevocable trust versus putting it with, say, like my oldest sister, who's the trust, you know, the executor of their will now.
Well, when we created the irrevocable trust, and when you create an irrevocable trust, because I'm going to have to talk in general terms,
sure,
because I can't talk about your mom
Absolutely.
and dad on the radio.
No problem.
Without their
They're great.
No problem. They are.
But
anyway, this is a good example.
Generally speaking, it's a great example.
Okay.
And if you and when you do planning for people in asset protection planning, what you're trying to do is segregate out their asset base so that a creditor cannot come back in and take the money away from the family.
Sure.
It's just that simple.
Okay.
So what you do is you create the irrevocable trust. An irrevocable trust is it can be utilized for the benefit of mom and dad while they're alive to a degree,
Okay.
and then at their death it passes along to the children. The purpose of like putting a house into an irrevocable trust is I can retain the right to reside in the house, but I can give the title and equity to into the irrevocable trust. So I can stay in the house and occupy it and use it as any tenant would use the property. But when I die, then the property is sold and the proceeds go out to the children.
Not you can live in the house. You mean the person.
The person who creates the trust, the grantor.
I'm like, wait a minute, he's going to live in my parents' house?
No,
What?
No, thank
Nice
you.
house.
No, I don't want to live in anyone's house. What it is basically is you have the person create the trust,
Sure.
and then they transfer into the trust the real estate, but they retain the right in the trust document to reside in the property.
How does that affect things when they go to move into a nursing home, let's say?
If depending upon when it's done, and if it's done timely, then after 5 years, the value of the home is not affected by going into a nursing home and applying for Medicaid.
Okay, so it helps the person, with
Segregates the assets and protects it. The asset protection is protection against creditors. Creditors are
Yeah, sure.
MasterCard, Visa,
Sure.
and or the state of Ohio and the Medicaid program.
Okay.
Because typically, if a person has a home and they go into a nursing home, they have 13 months to sell it,
Okay.
and then they have to use the proceeds from the sale of the real estate to pay for their care until it
Okay.
dwindles down.
Okay.
They can do some planning once the property sells, but basically half of the value of the property is going to be used for their care,
Okay.
regardless of what they do.
Oh, okay.
But with the irrevocable trust, if you do it 5 years before
Uh-huh.
you need it, or if you do, basically if you do it 5 years before, then 100% is protected.
Oh, wow. Okay, that's good information.
Well, yeah.
And I'm happy to know what that means now.
And planning always, you need to plan during your lifetime at different levels. When you're single, you need a will, living will, healthcare power, durable power of attorney. When you're married and you have children, minor children, you need a will, living will, healthcare power, durable power of attorney, and a trust that will take care of the assets for the minor children
Sure.
until they become an adult. Then when you retire and you have adult children, and typically grandchildren, you do a different type of planning, and you may consider an irrevocable trust at that point in
Okay.
time. So you use different tools at different times of your life. And if you go to our webpage, elderlaw.us, there's a whole series called Stages of Planning, and it goes through
Oh, nice.
each stage of your life that you typically go through, and what type of documents you need, and what you should consider in terms of planning.
And we'll make sure to put that on realtyresourceradio.com as well.
Yeah.
So that if you're listening, you can go there and find Richard's information.
And as to real estate, specifically, real estate's one asset that clients typically own. So most clients come in, they'll own a car, a house, they'll have an IRA, 401k, 403b, and then they'll have some money in investments, CDs. Typically, that's what people own.
Okay.
So real estate is one portion of the estate plan. When I'm looking at a husband and wife and I have adult children, I would have the house in joint tenancy with rights of survivorship.
Okay.
And what that means is that if one of them passes away, it automatically transfers to the surviving spouse
Okay.
without probate court intervention. So I
Okay.
don't have to go through probate, I don't have to get it appraised. All I have to do is file an affidavit with a death certificate attached, and it automatically transfers to the spouse.
I see that a lot in real estate. That's like the typical for married people.
Right,
That's
right,
correct.
right.
That one right there.
Right.
And then if you're single, you can do a TOD designation, which is a transfer on death designation. And if you do that, again, I'm a single person. My husband, my wife has passed away, and I have 2 children. I can designate them to receive it when I die. Now that's a designation; it's not a deed. That can be changed at any time. So you're basically just designating who gets it when you die. When I die, again, we file an affidavit with the death certificate attached, and the children own it the next day.
Okay.
Let's
Oh,
say
wow.
let's say you don't have this trust thing going on. Let's just say I have my house. I got my 401k. I have a will that just says basically give it to my kids. I pass away. does this go to probate court then? I
Yes.
mean, and what's involved there? Is there costs? Is there time? Is it hassle for people? I mean, that's what we're trying to avoid people, right? We're trying to avoid them from spending money and avoid this hassle to help out their beneficiaries.
Absolutely. When you die and you have assets in your name, at your death it would go through a probate estate. You would have to be appointed as the executor of the estate. That takes 2 to 3 weeks to get done. Then you have to have the property appraised. It's appraised by someone appointed by the court. They go out and look at the property. They come back and give us an appraisal sheet. We then file an inventory and appraisal. That usually takes another 90 days. So you're out, you're probably out 5 to 6 months before you can sell the property.
Okay.
As opposed to if I have a TOD designation or a joint survivorship deed, I can sell it the day after I get a death certificate.
And then is there costs involved then for
And there are
through
additional
probate
costs
and everything?
always when you go to probate, because you have to pay probate court costs, which usually run between $200 and $300. And then your transactional cost, and then you have attorney's fees. And if I have to go to probate court, it costs more.
So I might as well do it in advance.
If you do it in advance, you save money when you pass away for your heirs. Absolutely.
So with an irrevocable trust, what is the benefits to the parents and the children?
Well, an irrevocable trust puts the asset into it, and once it's into the trust, then it's protected from creditors. It just depends on who the creditor is. So if the property remains in mom and dad's name, if they have a creditor, if they get sued because they don't have enough insurance on their car, that becomes a creditor. They can foreclose on the property and they can get the property. If you put it into the children's names outright, then you're married to all of their creditors.
Oh.
And all their creditors can then sue and get a piece of the
Nasty.
property.
That's terrible.
So putting it into the irrevocable trust protects it from mom and dad's creditors in the future and the children's creditors
Okay.
in the future. And therefore, at the end of the day, when mom and dad are gone, you sell the property, you pay the bills, and you divide up the remaining net amongst the children.
Awesome.
So this is the way to protect your property, protect your assets, protect your money should something happen where you die.
Yes.
Well, this is a great thing for everybody. I think.
Yeah.
I think we need to go do this, honey.
I think so too. We need to set up an
Because
appointment, Richard.
I have my phone with me.
Okay.
It saves money.
We really do,
in the
for
long
real.
run, and it protects our assets.
Oh, yeah.
This is
Do
so
we have
everybody should
assets?
be
I'm
doing
just
this.
kidding.
Yes,
What assets?
we have two.
Can you also protect the debt and take it away from us? Just kidding.
Well, your existing debt cannot be avoided. That has to be disclosed, but future debt can be avoided. The Ohio just passed a new statute called an Ohio Legacy Trust. And this is a specific irrevocable trust that allows you to have a lot of control and dominion over it, but also allows you to protect assets from future creditors.
Awesome.
And it just came into effect last year.
Wow. Okay, that's different.
Richard, what's the best way to get a hold of you or your company?
You can call my office at 614-471-0085 or visit our webpage at www.elderlaw.us.
Browning
Perfect.
and Meyer.
Browning and Meyer.
Awesome. Thank you so much for
Thanks
being
again.
on.
No problem.
And we're going to have information out there on realtyresourceradio.com for you to find it as well.